computer is picking up a strange signal. Here, sir, you better take a look at it.
Hello and welcome to episode 116 of Life Through a Prison with your host Rob Tierney. In this podcast we may cover issues regarding LGBTQIA+, disability, pop culture. In this episode we're going to take a look at an article in the category of disability from abc.net.au entitled "Confusion about Disability Discrimination Law is Weakening Its Power to Protect People" by Peta Spyrou, Alice Taylor and Robin Banks, posted 2nd of December 2025. Since Australia introduced the Disability Discrimination Act, or DDA, people have talked about it as a major step forward for equality. The Act was meant to protect people with disability from discriminatory treatment and help create a more inclusive society. But more than 30 years later, it's clear that many people don't fully understand how the Act actually works. The Commonwealth Attorney General's Department review of the DDA has revealed confusion. Some people argue that the definition of disability in the law is outdated and should be completely rewritten. Others claim that some states like South Australia no longer use a comparator test to judge discrimination cases. Both claims are wrong, and these misunderstandings matter. If people, including lawyers, misunderstand what the DDA actually says, then its protections can't do their job properly. Misconceptions about the DDA. One common mistake is thinking the DDA has a narrow or old-fashioned definition of disability. Unlike other laws dealing with disability, the law deliberately defines this term in a very broad and inclusive manner. It covers all types of physical, intellectual, psychiatric, sensory, neurological, behavioural and learning conditions. It protects people who used to have a disability, might develop one in the future, or who are believed to have one. It is also flexible enough to cover both temporary and long-term conditions, including fluctuating ones like many mental health issues. This wide definition recognises that discrimination doesn't just come from someone's actual condition. It also comes from stereotypes and stigma. The unfair assumptions people make about what someone with a condition can or cannot do. For example, a person who wears glasses might not think of themselves as having a disability, but if they are refused a job because they wear glasses, the DDA protects them because vision is a bodily function covered by the Act. Some people say the DDA uses a medical model of disability, focusing on impairments rather than social barriers, but that's not quite right. The law isn't about labelling people or deciding whether someone counts as disabled. It's about preventing discrimination based on any condition that affects how a person's body or mind works. Calls to modernise or replace the definition risk doing more harm than good. If rewritten poorly, a new definition might actually exclude people who are currently protected. The real problem is not that the DDA's definition is too narrow, but rather that too few people understand how broad it already is. Instead of changing the law, we need better public education about what it covers. The complexity of unlawful discrimination. It's not surprising that there is confusion about disability discrimination law. Most lawyers and law students never studied in depth, and few workplaces train staff to understand it. As a result, the word discrimination is often misunderstood. People usually recognise obvious examples like refusing to hire someone who uses a wheelchair, but they may not understand more subtle ones as forms of unlawful discrimination. For instance, a workplace with rigid hours or no flexible options might unintentionally exclude people with certain conditions. That's a form of discrimination, even if no one meant to be unfair. Many people with disability grow up facing barriers so regularly that they don't realise all of the situations in which the law protects them. They often ask, if this is against the law, why is it still happening? The truth is that the DDA relies on individuals to take legal action when they face discrimination, which is difficult and often expensive process. This is one area of the law that definitely needs reform. At the same time, not every case of unfairness is unlawful discrimination. Disability discrimination laws are complex, and they draw careful lines about what is and isn't unlawful. Without clear education and guidance, expecting everyone to understand these details is unrealistic. The problem of the comparator test. Another area of misunderstanding involves how the law decides whether discrimination has happened. The DDA and most other Australian discrimination laws use what's called a comparator test. This means a court asks whether a person with disability has been treated less favourably than someone without that disability would have been treated. While this approach was once useful, it has serious problems. It assumes that equal treatment always means treating people the same, but equality often requires different treatment, like making adjustments so that everyone can access the same opportunity. For example, giving a blind student text-to-speech software isn't special treatment, it's about ensuring fairness. In some states like South Australia, the law uses the term unfavourably, but confusingly defines it as less favourably in Section 6, Paragraph 3. This kind of poor drafting creates even more confusion about what test is actually being used. Many experts argue the comparator test no longer fits how society understands discrimination today. Instead of focusing on comparing individuals, we should be focusing on removing barriers and creating inclusive systems that work for everyone. Disability discrimination is not just about isolated unfair actions. It's also about how structures, policies and attitudes can exclude people. The DDA remains one of Australia's most important human rights laws, but for it to protect people effectively, everyone, whether in the government or in the community, needs to understand it correctly. The definition of disability isn't the problem. It's already broader and more flexible than many people realise. What's missing is clear information, education, and the political will to make other parts of the DDA more effective. Had you heard of the Disability Discrimination Act? For myself, I've heard it bandied around in different parts, but no discussion went further, just the name. Do you think that the DDA is still effective? Does it need to change with the times in a real and long-lasting way? Would love to hear your thoughts. Till next time, take care, and bye for now.